Hi, everyone. Welcome to our webinar, Data Sharing Opportunities and Risks. I'm excited to be here today with my partners and co-presenters, Ed Brooks and Michael Paparesky. In this webinar, we're planning to cover laws that apply to data sharing and value-based contracting, so requirements for business associates, qualified service organizations, data sharing by health apps, proposed modifications to HIPAA, enforcement actions against healthcare providers, which Michael will cover, and recent litigation trends, which Ed's going to cover. So the point of this webinar is to really bring interest to companies and insurers that partner with providers for value-based care and their provider participants. But it's also a really good refresher just on general data privacy risks, so should be helpful for both categories. And so I'm going to do some general introductions, some housekeeping items, and then I will turn it over to Michael and Ed to do their introductions as well. So a little bit about the firm. McGuireWoods has 1,000 attorneys, 21 offices. We have been providing legal services for over 188 years. Our healthcare group, which I'm a part of, has over 50 dedicated attorneys. We work on regulatory compliance, mergers and acquisitions. The litigation group that Ed's part of comprised of trial lawyers, litigators who handle disputes in all jurisdictions, state, federal courts, regulatory agencies, arbitrations, has extensive experience handling bet the company litigation. And then the government investigations and white collar litigation department, which Michael is part of, is also nationally recognized. More than 80 attorneys, represents Fortune 100 companies and individuals at the federal and state level. So let's see here more about the firm. I work with a lot of great colleagues, lots of awards that they've won, lots of information here that you can click through at your leisure. We are going to share these slides after the presentation. So quick housekeeping too, there are I think it's the bottom left corner, there's a Q&A icon if you'd like to submit questions throughout the presentation. We will answer those as we go through the presentation as well as at the end. If we run out of time, we will catalog those and we will respond to you in email since we have everyone's email. I believe you can access the download the presentation slides. Those will also be sent to you via email after the presentation. CLE credit is available if you would like it. You probably already provided that information, but if you didn't during your registration, then please, again, reach out to us. And we are lawyers, we love disclaimers. So the disclaimer, this does not create attorney-client privilege. This isn't legal advice. We're providing you training and information for you and your colleagues. So if you have any specific legal questions, please reach out to us. We would love to speak with you. So a little bit about myself. I am in the healthcare department. I co-lead our digital health technology and innovation subgroup. So I work with healthcare companies across the spectrum on mergers and acquisitions, all things digital health, data privacy, work with health apps, emerging technologies on software as a service. I do a ton of work around HIPAA breaches, work on HIPAA policies and procedures to really help my clients make sure they're ready to go in the event an employee steals information or a flash drive with patient records or whatever is lost. I also have a podcast, Health Plus Tech, and I'm a weekly guest on Becker's Healthcare Digital Health Podcast. So if you have any interest in those, check them out on Apple Podcasts. So I'm going to turn it over to Ed to introduce himself.
Thanks, Andrea. So I'm Ed Brooks. I'm a partner in the Chicago office of McGuireWoods. I'm a co-lead of the healthcare litigation group. I've been doing healthcare litigation for over 30 years. I practice in courts and also do a lot of arbitrations. I was an adjunct professor at Northwestern teaching trial ad for over 17 years. I'm also a arbitration neutral for the AHLA and the AAA. So I do arbitrations as a neutral as well. I've been doing this for a long time, and I'm going to kind of weigh in on the issues of the civil risks from data sharing, and we'll be talking to you about that in a moment. So that's it. Michael? You may be on mute, Mike.
Thanks, Ed. And thank you, Andrea. My name is Michael Podboreski. I'm a partner in our government investigations and white collar group and co-chair of the False Claims Act investigation litigation team. So I joined McGuireWoods about a year and a half ago from the Department of Justice, where I was a prosecutor in the civil fraud section, where I prosecuted False Claims Act cases for 6 years, primarily in the healthcare space and then a little bit in the procurement space, particularly defense and aerospace, which aligns with my background as a former naval flight officer. Prior to joining the Department of Justice, I was at another large international law firm for 7 years. And looking forward to, after Andrea talks about all the opportunities presented by data sharing, I'm going to talk about some of the enforcement risks that are out there.
All right, thank you. So value-based care, that is really the main topic here. And so you hear this term value-based care over and over again. And it's been around a long time, but it seems recently, and it truly is recently, there's a lot of focus on it from HHS and CMS. So value-based care is an alternative to fee-for-service reimbursement. So fee-for-service reimbursement is payment for the service provided. And value-based care, alternatively, is a payment for a group of services to show that, to incentivize good outcomes and lower money spent on that care. So instead of promoting a number of services, you're trying to encourage preventing disease. You're trying to treat problems early. You're coordinating, communicating between providers and payers. So it's based on outcomes and how well providers can work together to reduce hospital readmissions, to use certified health IT, to improve preventative care. So as you can imagine, payers love this, including the federal government, because they want to contract with providers that have these mechanisms in place to control utilization, so reduce costs for the payers, and ensure quality of care. So an example of this would be if CMS's individuals is undergoing surgery, and CMS would pay the hospital, the surgeon, and the anesthesiologist in one payment instead of separately. So this is an opportunity for providers that if they can save or reduce their costs, they can then share in the bundled payment to the extent there's additional money there. Or if they aren't able to, then they potentially have a loss, right? So providers are potentially bearing out the risk of a financial loss. So how does this relate to data sharing? And I like to think of all healthcare companies are really data companies. Data infiltrates everything we do, whether it's actually providing care, whether it's on the payer side, whether it's electronic medical records. It's so incredibly important. And in value-based contracting, it requires a vast amount of patient data to actually work and to be effective. So what I hear over and over again is I don't have useful data. I have data, but I don't really have a great way to figure out how to use it in a way that's productive and will allow me to reduce the cost of care and therefore benefit from these value-based care bundled payment arrangements. So a lot of times in reality, healthcare providers aren't really interested in value-based care. They lack the data. They don't have confidence that they can use the data to improve outcomes, and they have to accept this downside risk. But at the same time, CMS is really pushing this. They want all Medicare payments to be through value-based care models in 2030, which is unfortunately going to be here before we know it. So updated data in 2020 shows that there's actually been a lot of money saved already. CMS is saying $4.1 billion through these value-based care arrangements. And again, hoping that we're going to get everybody to value-based care by 2030. So when you are sharing data, whether it's in these value-based care arrangements or really in any situation, you're going to have several laws that you want to pay attention to. So we're going to start out with HIPAA. This is obvious. Any healthcare provider, you're probably very, very aware and understand HIPAA very well, but just quickly covers covered entities, business associates. Covered entities are your providers, payers, and healthcare clearinghouses, and business associates are entities that provide a service to these covered entities and also receive PHI. So in value-based care, since your data is flowing from the healthcare provider to the healthcare payer, you have to consider HIPAA. But it's quite easy in this situation because there's the treatment, payment, and operations exception, what we call the TPO exception, and patient consent isn't required in this situation. So the idea behind TPO is just you want to allow sharing of PHI when there's really, it's needed to make sure there's no barriers to accessing treatment or payment or actually running of the healthcare provider. What's interesting and different about HIPAA that providers and payers should be aware of is early in 2021, HHS came out with proposed changes to HIPAA, which was a big deal because we haven't seen changes for a very, very long time. This was part of the regulatory sprint to coordinated care. There were revisions around the same time to Stark and anti-kickback, which have since been enacted, but we don't have a final rule yet for HIPAA and what changes are going to be adopted. If you're interested in this, I've done an entire webinar on this topic, so feel free to reach out. I'll send you the recording and a bunch of different alerts and written summaries, so happy to share those with you. But what's relevant here to value-based care is HHS is saying, providers are almost being too conservative about sharing information for provider-based, value-based care. So HIPAA allows data, PHI, to be shared for what population-based care, coordination, and case management. And so that's right in the statute. And a lot of providers are saying, well, actually, this is for individual-based care, so I'm not going to share because it's too risky for me. So HHS came out in the proposed rule and said, which is actually very helpful, said, we aren't actually going to change the language, but we just want to let everyone know that you can do this for individual instead of population-based care coordination. So even though this rule is not final, that's great language. If that's something you want to do, and as a healthcare attorney and HIPAA expert, that's great because we have something to point to which supports kind of what our historical analysis has been. They're also proposing changing the minimum necessary rule. So this basically requires covered entities when a payer requests information to make sure the information the payer is requesting is the minimum necessary. HHS is saying, we're going to get rid of that. If the payer says they need it, we're not going to make you do an independent audit on whether it's minimum necessary. That has not been adopted yet, but it's something to keep in mind. These are two of many, many changes, so it's just something to put on your radar and continue. We'll see if we get anything in 2022, but hopefully 2023 we'll probably see things. And if we do, all covered entities, all business associates need to modify all their policies and procedures, their forms, et cetera. So it's definitely something to be aware of and to watch. Data use agreements, I'm going to run through these pretty quickly because they're not as relevant to value-based care, but I want you to be aware of them since we're covering a lot of just general data use topics. But data use agreements, different than business associate agreements, Those are for disclosure of limited data sets, which are basically a smaller subset of information. So this would include dates, admission dates, city, zip code, age, unique identifiers like that can be disclosed to non-business associates if you have this data use agreement. Sometimes used in this circumstance, really see it a lot with research. So just flagging that in case that is helpful. 42 CFR Part 2. This is really important for any entities that are going to have access to patients' substance use disorder records. I find that this is frequently forgotten about by a lot of providers, but it's very important to make sure as part of your analysis on what rules you need to comply with. Obviously, if you have a substance use disorder, this is incredibly sensitive. You probably don't want to share this information, so your records are protected, and more than HIPAA, like it's another step above HIPAA. So you have to have consent for any releases. So this is important for value-based care as well as all providers because you need that patient consent, unlike HIPAA where you can share information without consent for treatment, payment, and operations. Like HIPAA, 42 CFR Part 2 was revised. So there's a final rule for that one, but not for HIPAA, to say that if you're a lawful holder of this information, you can again share it for case management purposes. Patient is in control. So this one's, I think, pretty interesting because, and it's particularly of interest to any company that is a software provider or creates health apps. It's just crazy how many health apps are part of the Apple Store or wherever you download your apps. There's like 350,000 of them or something like that. I think I have like half of those downloaded on my phone, right? So there's tons and tons of them. A lot of these app creators think, well, HIPAA doesn't apply to me because I'm not a covered entity and I'm not a business associate, so I'm good. It does. Where people get tripped up is there's an FTC data breach rule. Historically has not been enforced. And recently there's a women's health app called Flow, collects a lot of women's health information. They were selling the information to Facebook, of course. FTC came back and said, hey, you're not covered by HIPAA, but this is obviously a big problem and we're going to start enforcing this going forward. So if you are subject to the FTC data breach rule, it's pretty remarkable what you have to do. And you have a rapid 10-day notice to the FTC. I don't know about you, but if you've experienced the data breach, 10 days is like crazy to make notices to the government, 60 days to notify everyone involved, and then $43,000 per violation per day. So as you can imagine, that could be just a crippling situation. So this is one to keep on your radar, and we do expect there to be more enforcement on that. Interesting, and I was just reading something about this yesterday, but there's also a push for wellness apps to be reimbursed by insurance. So again, if you are a provider of health apps, this is something to keep on your radar as well. They're called prescription digital therapeutics. So these are basically software programs that have been studied in clinical trials. They receive FDA approval, and they will be for things like substance use disorder, IBD, anything that really behavior change can help with. You could use these apps. Your physician could prescribe the app to you, right? And so they've received a lot of funding, $40, $50 million on several of these companies to continue developing these apps. There's one for breast cancer that women will go through and make sure they're taking steps to reduce risk factors, and that will be prescribed and covered by insurance. So mention that because if you are a health app or you have a health app, how great would it be if your users don't have to pay or you don't have to rely on advertisements, but instead Medicare, Medicaid, or private insurers would pay. So that's, we'll see how that goes, but it's definitely something exciting that's happening. And then that is the main pieces I wanted to cover. Just wanted to plug two about patient access. HHS is really focused right now on making sure that covered entities and business associates, if they request access to their data, that they receive it promptly. HHS has brought 30 different enforcement actions in the last year against providers that are failing to give healthcare data to those that request it. So something, again, to keep in mind and pay attention to as you are providing patients access to their information. So that, I'm going to turn it over to Michael.
Thank you, Andrea. So there you have it. There's a lot of opportunities presented by data sharing and data analytics, and the government is encouraging that. And as I previewed, there are some landmines out there. With the left hand, the government is sort of pushing this collaboration that will support value-based care and efficient outcomes and cost savings and better quality care. On the other hand, the government is really amping up its enforcement of HIPAA violations and actually spinning a HIPAA violation into what they're now calling cybersecurity violations, which is a real priority area for the department. So, you know, on the one hand, encouraging it. On the other hand, there are real landmines out there it's worth talking about. So a bit of background about the enforcement spectrum, what tools investigators have at their disposal, and then we'll get into what enforcement has looked like in the past and what we predict and project it'll look like going into the future. So the enforcement spectrum, you know, if you look, imagine the left part of the slide as sort of the softer end moving towards the right end, which is the harder end. So on the left, you have administrative remedies. It can be as simple as rejection of a payment claim, necessity for prior approvals, imposition of civil penalties, all the way up to suspension or revocation. Of course, for some providers, being suspended from a federal health care program or excluded from federal health care programs is a professional death knell. So that's not to suggest that administrative remedies should be taken lightly. In the middle, you have civil enforcement, including the False Claims Act, which is the government's primary fraud enforcement tool, and one we project will be used more frequently to go after entities that have HIPAA violations or cybersecurity violations. And most states, the vast majority of states, also have what are called mini False Claims Act, which are essentially equivalents to the federal False Claims Act. And then on sort of the harshest end, you have criminal provisions, your fraud laws, wire fraud, bank fraud, conspiracy laws, and particular to this topic, wrongful disclosure of identifiable health information where it's done intentionally can get you crosswise with criminal prosecutors and lead to steep penalties, including orange jumpsuits. Now, what tools do investigators, agents, prosecutors have? Again, working from sort of softest to hardest, you can receive administrative requests from Medicare administrative contractors, ZPICs, UPICs. You can get a letter from HHS, Office of Civil Rights, you know, that letting you know that there's an informal inquiry. You can receive a civil investigative demand, which is what a False Claims Act subpoena is called, and those will be requests for documents, interrogatories, and/or testimony. Prosecutors also have at their disposal what are called IG and HIPAA subpoenas, but those are for documents only. Agents can interview current and former employees, and they don't have to come through the company to do that necessarily. And then working our way towards the criminal end, there are search warrants, grand jury subpoenas, and the full panoply of covert tools, surreptitious recordings, video, so on. So traditionally, the government has handled private information violations in the healthcare realm under HIPAA using HIPAA civil penalties. And those are enforced by the Department of Health and Human Services Office of Civil Rights, which is responsible for investigating and enforcing HIPAA. Traditionally, since HIPAA came around about 20 years ago, OCR would use non-punitive measures such as compliance agreements or technical guidance to address HIPAA violations. And we've got some numbers for that. So there have been 30,000 violations over the past 19 years that were resolved by changes in practices and or technical guidance, and only 106 cases resulting in civil monetary penalties totaling $131 million. For serious violations, OCR will impose a penalty that are based on one of 4 tiers. So less serious violations have a lower fine, and as you work your way up to category 4, more serious violations that demonstrate willful neglect and no effort made to correct the violations will have higher penalties. And again, the tenor of this slide is traditionally OCR has been wanting to work with companies to fix the problem and not necessarily focused on penalties. But that's not to say when they do impose penalties that they can't take a serious bite. So here are some examples of some of the largest HIPAA penalties from the past 3-4 years. So I'll just the first bullet: health insurer pays $5.1 million to settle data breach affecting 9.3 million individuals. Third bullet from September 2020: a health insurer paid $6.9 million to settle a data breach affecting almost 11 million people. And then the last bullet from October 2018: a large insurer paid $16 million following another data breach. So again, OCR traditionally has been more focused on correcting the behavior and working with companies to do that without being punitive, but they certainly can be punitive, and that punishment can be for significant dollars. Now, that said, we think the shift is going to be more enforcement of HIPAA violations and cybersecurity violations using the False Claims Act. And we'll talk a little bit about the False Claims Act. It's the government's primary fraud enforcement tool. Now, that said, it traditionally has not been used for privacy violations. But as you'll see, that's changing and going to change more in the future. So the False Claims Act provides for treble damages and per invoice penalties. So treble damage is a fancy lawyer word for triple damages, and per invoice penalties takes on a significant impact in the healthcare realm. When the government buys a tank or an airplane for the Department of Defense, there may be one invoice for that $100 million tank or aircraft, $100 million aircraft. When my grandmother would go to the hospital for a few days with a type having trouble breathing, that 2-day visit could generate 50 separate invoices. So and the invoice penalties can be as high as $25,000 each. So in the healthcare realm, the per invoice penalties take on extreme significance. Other unique aspects of the False Claims Act is it has a whistleblower provision which allows private citizens to sue on behalf of the government and recover anywhere from 10 to 30% of what the government is awarded or settles for. And basically, in this context, the allegation of a cybersecurity or a HIPAA violation, the allegation under the False Claims Act would be that the government did not get what it bargained for. That when the government pays for a medical service, a healthcare product, they are paying for a whole bundle of services and promises. And one of those promises is that the data for the beneficiary will be properly protected. Over the last decade, DOJ has recovered $2 to $6 billion per year under the False Claims Act, so significant sums of money. Last year, DOJ obtained $5.6 billion, which was just under their record. $5.1 billion of that was in the healthcare sector, and there were several settlements with Medicare Part C providers, the value-based providers, including $90 million with an insurer alleged to have inflated diagnosis codes. The largest ever False Claims Act settlement with an MAO plan was in 2018 for $270 million. So you can see the numbers here compared to the couple slides before. $16 million for a HIPAA violation is a lot, but it's just a fraction of $270 million. So the False Claims Act can really take a significant financial bite. So the Biden administration has made some pronouncements. Some have been expressed, some have been more reading between the lines. So in general, both during the campaign and in the past year, there's been promises that there will be more corporate enforcement. The budget request for next year included funds to hire hundreds of new prosecutors and agents focused on white-collar and corporate crimes. Medicare Part C, DOJ has repeatedly highlighted Medicare Part C as a priority area of enforcement as more Medicare beneficiaries choose to go that route instead of the traditional fee-for-service. DOJ officials have also repeatedly identified data protection as a priority fraud enforcement area. And in this area, they have not been coy about it. They've been very clear, so much so that in October 2021, DOJ announced its cyber fraud initiative, and they promised to, and this is a quote, combine the department's expertise in civil fraud enforcement, government procurement, and cybersecurity to combat new and emerging cyber threats to the security of sensitive information and critical systems. Now, what does that mean? It means they're going to start using the False Claims Act to prosecute data breach and security matters involving federal contractors, and that includes entities that contract federal healthcare programs. It's not just your large defense and aerospace companies. It includes anyone who has an MPI number and bills to Medicare and Medicaid. So they make the announcement in October, and just this last March, so right about a couple months ago, DOJ prominently announced its first settlement under the False Claims Act under the Cyber Fraud Initiative. So it was a $930,000 settlement with a contractor that provided medical care to Department of State and DoD personnel in Afghanistan and Iraq. The press release touted in its headline, this is the first resolution of an FCA case under the Cyber Fraud Initiative. So there were two sets of allegations. The first was that the defendant provided U.S. government personnel with prescription drugs that were not approved by the FDA. They came from a third-party country and had not been inspected by the FDA. And that both violates the contract and federal law, federal prescription law. And the second allegation was that the defendant improperly stored patients' PHI on an unsecured server. So despite the potential for patient harm associated with providing unapproved controlled substances, in its press release, DOJ heavily emphasized the HIPAA violation, which they puffed up to a cybersecurity violation, and sort of took a round peg and fit it into the square hole so they could have their first scalp under the Cyber Fraud Initiative. And to demonstrate that, here's a quote from the press, right out of the press release, from the Acting Assistant Attorney General of the Civil Division. This settlement demonstrates the department's commitment to use its civil enforcement tools to pursue government contractors that fail to follow required cybersecurity standards, particularly when they put confidential medical records at risk. We will continue to ensure that those who do business with the government comply with their contractual obligations, including those requiring the protection of sensitive government information. So this is a bit of a sea change over at DOJ. Traditionally, when it comes to healthcare enforcement, patient harm is really prominent. And you're talking about, giving airmen and Marines and Army soldiers and Department of State diplomats drugs that weren't approved by the FDA, and the dangers that pose. To really sort of downsell that and then really upsell and highlight violation, the PHI violation, which, by the way, they're in Afghanistan. It's not like they can go to Office Depot or call up Cisco and easily get servers. They used an improper server because they were probably dealing with what they had, and to turn that into the main allegation, I think reading between the lines, it really shows the Department of Justice is itching to have scalps under their cyber fraud initiative, and it portends further enforcement of data breaches and improper handling of data under the False Claims Act. So a little more tea leaf reading. I think OCR will likely rely more on punitive tools and less on corrective action and guidance in addressing HIPAA violations. OCR and whistleblowers will refer more HIPAA violation matters to DOJ for investigation instead of handling those administratively. Expect more data breaches to be treated as subjects of False Claims Act enforcement investigations, actions, and settlements. And in general, expect penalties and fines for privacy violations to increase. A quick word on antitrust concerns from my colleagues in my department who focus on this area. Data sharing also presents opportunity for antitrust violations. The DOJ Antitrust Division has signaled increased enforcement and use of all tools, including criminal prosecution, to combat unlawful monopolistic conduct and agreements not to compete. The fairly recent repeal of the McCarran-Ferguson Act antitrust exemption for healthcare insurers widens the scope of potentially actionable conduct. That said, generally data sharing meant to develop best practices and improve efficiency and outcomes will not be challenged, and this is a quote, absent extraordinary circumstances, as long as the exchanges fall into the safety zones established in the FTC DOJ statements of antitrust enforcement policy in healthcare. So to sum it up, data sharing may draw the attention of antitrust enforcers if it appears that the exchange is related to anti-competitive agreements among competitors, including both express agreements and tacit understandings. A very brief word on mitigation strategies. What can companies do to protect themselves from being subject of an FCA action, press release, settlement, or litigation? Seek assistance from compliance or counsel if there are data privacy or sharing concerns. Leadership should ensure there's a robust and proactive data privacy compliance programs. I mean, a lot of folks listening in know what how important a good compliance program is and what the elements of a good compliance program are. Data privacy needs to be a part of that if data sharing is something the company does. An effective compliance program will help protect the company by, 1, nipping problems in the bud, 2, identifying problematic regions and providers, and 3, if something does happen, there is a breach, there is an accusation, DOJ will review the compliance program. If it looks like a strong compliance program, something just slipped through the cracks, that will mitigate sentencing or decrease settlement amounts. And what does an effective compliance program include? And hopefully all you listening, your companies do this. Proactive risk assessment and data and record review, document training, confidential reporting structure, involvement, engagement of senior managers, compliance officials that have autonomy and resources, and quite frankly, a direct line to senior management, incentives and disciplinary measures when mistakes are made, incorporation of lessons learned and continuous improvement, and periodic testing and review. And all these elements come right out of DOJ guidance on what they expect an effective compliance program to look like. So with that, I'm going to turn it over to Ed.
Thanks, Michael. So what I'm going to cover is, let's call it the civil side of this. Michael talked about the enforcement side and all the parade of horribles, that can happen there. from the government side. I'm going to talk about the civil side. So what kind of lawsuits, do we see? What are the claims? And what are some of the arguments that you can make to mitigate this risk? What I'm not going to do is read cases to you or identify cases, because I think that's counterproductive. But I do have, for anybody's interest, a zip file of the most recent decisions that we could find on data breaches, and you can get a sense of what they look like, what the claims are, and that sort of thing. I don't know what the breakdown of litigators is in this audience. I suspect probably less than more. And so, again, I'm not going to even cite a single case. I'm just going to talk high level here. So the kinds of cases that come out in the courts fall in the lines of these kinds of fact patterns. The provider hires a collection agency, and the collection agency has the PHI and PII, and there's an unauthorized use or a data breach. Another fact pattern would be a health benefit plan that's either the ASO or might be the plan actually providing the insurance, the at-risk plan, in which case there's a data breach, and the members, whether they be employees or if it's a at-risk plan, then the members' PHI and PII is released. Could be a ransomware attack. It could be spear phishing. The other situation you see in the case law is a health plan that had a contractor. Sometimes health plans hires contractors, or providers hire contractors to review medical records. There's a case where the contractor used the data for training purposes, and unauthorized folks got access to it. There's the stolen laptop scenario. We've all heard of that. Another scenario in the case laws where a medical management company is managing the practice or provider in a certain segment, and they have a data breach. So that's the fact patterns. The injuries that you typically see alleged in the cases are range in severity, and I think it's important to understand these allegations, because it really ties in with the ability to move to dismiss complaints in court. And the kinds of injuries that are typically alleged are risk of future harm to the PHI or PII, attempted but unsuccessful fraud, meaning finding out that somebody's trying to get access to your accounts or your credit card, out-of-pocket losses to protect your information, losses due to actual losses due to stolen identity and, for example, opening up new credit cards or charges on your credit card. And then you'll get the claims about anxiety and that sort of thing in dealing with the data breach. So the kinds of legal claims that you see in the court range in number, but there's sort of the usual suspects, and these are the causes of action that you typically see. You'll see a negligence cause of action, and that's just your typical, you have a duty to protect the information, you didn't protect it, so you breached that duty, causation and damages. So a negligence, straight up negligent claim. You'll also get many times a breach of implied contract. So the implied contract is one that the law imposes based on the circumstances. And what that is a contract to protect the PHI and PII. So the health plan who gets the PII or PHI, or the provider who gets the PII or PHI from the member or the patient, based on that relationship, the law imposes a duty. Or there's an understanding that there's a contract that's been created to safeguard that information. Another claim you'll see is unjust enrichment. This is otherwise kind of a implied in law contract, but it's basically where the allegation is that in the case of the provider or the health plan, they were unjustly enriched because they released the data, yet they were paid to keep it and protect it. You'll also get violations of consumer fraud acts. And so various states have Consumer Fraud and Deceptive Trade Practices Acts, and they have unfair trade practices. Those are unique to each state, but you're going to usually get those. And the scenario there is that it was a deceptive act to say you were going to, for example, protect the information and you didn't. And those are very heavily state law oriented, so you really have to kind of look at that closely. There's invasion of privacy, and then there's breaches of confidence. Those are also common law state claims that you'll see. Those are typically known as intentional torts, so it requires an intent, meaning an intent to release the data. Real quick, I know I want to make sure there's time for questions, but real quick, these cases kind of stack up this way in terms of trying to defend them. I don't know, again, I assume most of our audience are either health plans or providers, so you might be interested in defending these claims. But the way they stack up that way is the first argument you typically see is a standing argument. In other words, a motion to dismiss based on standing. Then you get into whether or not the complaint actually sets forth a claim for the various causes of actions I just talked about. Standing means that there's actually an injury in fact, and there's various ways to describe what standing is. It depends on the court you're in, but it's got to be distinct and concrete. It can't be abstract. It can't be possible, or it has to be probable. It can't be hypothetical. So the kinds of claims that actually survive a standing argument, and by the way, this is a really good way to attack these claims. Almost every case starts off with a standing argument. But the claims that typically survive are where there's an actual injury, obviously, where there's a fraudulent, credit card that's opened up or a fraudulent account that's opened up. But there's also claims that survive when there's foiled attempts to make charges, when there's attempts to sell PHI or PII, or if you could show a diminution in value of your PI or PII, or if there's even a substantial risk. There's a couple of cases out there, I believe the 11th Circuit example, that finds if there's a lot of data that gets released about you, that would qualify for standing because there's a substantial risk of future identity theft. So that's something to keep in mind. Claims that don't survive standing typically are a fear of misuse or a risk of misuse that's not imminent, or an increased risk of misuse. In some cases even go so far as to say even if there's some minor expenses incurred to mitigate a risk, it's not enough for standing. So again, I want to leave some time for questions, but the next way to attack and defend against these kinds of claims is that you would look at each cause of action carefully and make sure that the state law, for example, if it's a common law claim like negligence or the Consumer Fraud or Unfair Trade Practices Act, or the breach of confidence or privacy, if it actually states a claim. And you would do that by analyzing the allegations and looking at them closely as against what's being pled. There are several of the cases that we've found recently that are class action cases. I would definitely, those can be defended, on class cert, of course, separate and apart from the underlying causes of action. And those, you would look at whether or not the alleged injuries are individualized or meet the predominance requirement in class actions, and that's certainly something else that's really important to look at. The last thing I will note is just that as far as mitigation strategies, much like the things that Michael were talking about is policies and procedures in place that protect the PHI and PII, compliance programs around that. And that would include, assessing the risk, getting senior management involved, having timely reviews of your policies and procedures and that sort of thing. And that's how you would handle that. So I'm going to go ahead and wrap up. And I think there's one slide left for key takeaways. And the key takeaways, as we started off with Andrea, I think everybody would probably prefer to listen to her than me or Michael, and I don't blame them. But the key takeaways are that there's real opportunity in the future. I think this is the move in the future, as many of you already know, is that this increased data sharing presents opportunities to work together, payers and providers, and you're seeing more and more of that. But it does, present risks, and I think the bigger risks are probably, the stuff that Michael's talking about. I think the feds and the state enforcement agencies are going to be coming down hard on this kind of thing. On the civil side, there are big, based on my research, there are some big awards and that sort of thing. But I'll tell you, by and large, a lot of these complaints get dismissed. And a lot of them are not that significant. There's a handful, and I know some of you have seen those out there, but I think the bigger risk is the enforcement risk, and the any penalties that come out of the enforcement agencies. And the last bullet is sort of the obligatory. If you do get in trouble, seek help, and by all means call McGuireWoods. So I'm going to leave it at that and see if there's any Q&A in there.
I don't see any.
Okay. Yeah. Thanks for saying that. I was looking for it. All right. Well, I think why don't I ask a quick question, because I can't help myself. Michael, I think we've got a couple minutes left, and I'll give you back your time to the audience. I'm sure they'll appreciate it. But one question is, what's the best advice you have? I mean, you prosecuted these kinds of cases. And so what's the best advice, if you could sum it up in a couple of bullets, to a company or to the leadership of a company who gets the knock on the door from the authorities, and they ask you they tell you they got a subpoena, and they either a subpoena or not a subpoena, and they want to sit down with you and talk to you and your leadership about what they think is a violation. What do you recommend?
So, oftentimes the way the company will find out about it is that they will get the subpoena and ask them to produce documents or show up for a deposition in 20 days, 28 days. And it'll be accompanied by dozens of requests that are extremely broad, all documents, all communications about this topic. Right away, the company should retain counsel. This is not the type of issue you want to sit on it for a week and sort of think about it. This is one of those, as quickly as possible, go seek out your trusted counsel and have them contact the prosecutors right away. Especially in light of those tight deadlines, you want to get those deadlines stretched out. You want to find out what the prosecutors are really looking for. What is this about? Is there a whistleblower out there? Is there, maybe it's plain on the face of the subpoena, it's about a specific data breach, in which case there's not much mystery, or maybe the company will have no idea what it's about, and those counsel-to-counsel conversations can fill those in. The other thing those early conversations can do is really prioritize and focus the requests. The government intentionally writes very broad requests in case they ever have to go to a court and move to compel and enforce those requests. But oftentimes they're not looking for 5 terabytes of data, which will cost the company a fortune to produce and be very intrusive. Oftentimes, they'd much rather have the 500 important, on-point, relevant documents than a million documents that only includes 500 that are relevant. The rest are garbage. So those counsel-to-counsel conversations are important for really narrowing the scope of the discovery requests and focusing those efforts. And then the company and counsel may be behind the government, right? If it's about a known data breach, maybe the company has already investigated and remediated the issue. But oftentimes you get the subpoena, you have no idea what it's about. There's no data breach that you're aware of. Maybe it's not a public data breach. Maybe there's an allegation that information was stored improperly, like in the example I provided. And so the company is going to want to do a very quick and thorough internal investigation, try and get their arms around what happened here. Did we mess up? Because that's going to drive your strategy and how you interact with the government going forward. Do you self-disclose? Do you, if it's really ugly, maybe you hit the ramparts and you give the government what they ask for, but you don't cooperate an ounce before that. In most cases, it usually behooves the company to keep those lines of communication open and at least appear like they're cooperating, particularly in the False Claims Act context. And Ed, you touched on this in the civil litigation realm. And it's good advice in the False Claims Act context as well. There's a lot of cases where the government opens an investigation because a whistleblower filed a complaint, and the government will decline to intervene in 3/4 of those cases, and only will intervene in about 1/4. So there's a lot of room for persuasion, though. Just because there are areas where if the government opens an investigation, they're going to get a result. And there are types of subpoenas, like if you get a grand jury subpoena and the government tells you you're a target, the government's probably been investigating for a few years and they're pretty sure you're guilty of something and they're going to take action appropriately. False Claims Act is not like that. Just because you got a subpoena doesn't mean the government has reached any conclusions. There's room for persuasion. There's room for cooperation. So usually it'll make sense to keep those lines of communication open and work with the government. But every set of circumstances is different, and that internal investigation will help drive those decisions, those strategic decisions.
Okay, I think that's probably it. Thank you very much, everybody, and hope you join us again sometime soon.
Thank you.
Thanks, everyone. Thank you, Ed and Andrea.